All right. Good afternoon, everyone, and welcome to our first In the Boardroom for 2024. I'm Sarah Diedrich Kasdorf, Director of Outreach and Member Engagement for the Wisconsin Counties Association, and I'll serve as your host for today's educational webinar. Today we have an exciting topic, one on which Andy Phillips and I have been receiving numerous calls as of late, and that is social media usage by counties. Before we get to the topic, I just want to take care of a few housekeeping items. First, if you have any questions during the presentation, please type them into the chat or the Q&A function of Zoom, and that's located on the bottom of your screen. We'll try to work the questions in as we go along the best we can. However, we also need to make sure we get through the program material, so questions may be held until the end of the presentation. Second, a recording of this presentation, along with the PowerPoint slides, will be posted on the events page of the WCA website, likely within the next 24 to 48 hours. So with that, I have the great fortune of introducing our presenters for the day, who are no strangers to our In the Boardroom series. Now, as the full title of the series is In the Boardroom with attorney Andy Phillips and Attolles Law, I'm sure many of you are expecting Andy Phillips today. Well, Andy was planning on joining us. However, the legislature threw us for a curveball. The assembly decided to go into session. Andy was supposed to testify at a hearing at 10 a.m. this morning on the only bill that was on the agenda for that particular committee. Unfortunately, with the assembly deciding to go on the floor, that committee hearing has not yet started. So we have a little change up in who we were expecting to join us today. So first we have Rebecca Roker. Rebecca, by the way, was just nominated for an Oscar for Best Supporting Actress for her role as a disgruntled citizen at our mock board meeting during the Parliamentary Procedure Concurrent Session at our annual conference. You may have missed that announcement yesterday when all the other nominees were announced. So we're very happy to have Rebecca joining us. Also joining us today is Jake Curtis. Jake, thanks for filling in last minute for Andy here. I know you weren't planning on this for today, but we appreciate you taking the time to join us. So with that, I'm going to turn it over to Jake and Rebecca. And again, I'll be monitoring for questions along the way. But again, keep in mind, we may not get to all of them until the end.
Thanks, Sarah. Good afternoon, everyone. Sarah, thanks for that announcement on the Oscar. I appreciate the fact that my claim to fame now is the WCA conference. So glad it was informational and brought joy to people. So today we've got a very exciting topic and a very hot topic, social media in the boardroom for again with Andy Phillips, and Andy's obviously not here. So thank you for having us, Jake. Again, thank you for joining. Any intro comments that you'd like to make?
This is definitely a hot topic. Typically, I think when we've talked about this, it's been within kind of the context of public records, open meetings, and we'll touch on that briefly at the end. But I think really what I think is helpful for this presentation is we're going to do a deep dive on kind of the constitutionality of some of this content you see on social media, where those lines are. I think as we dig into it, it's going to become very clear that those lines are often very much blurred. And so, I think it's a hot topic, but before we even get to the public records open meetings, which is where we typically talk about this, I think this is going to be really helpful to understand how does the First Amendment impact, for example, a county supervisor's comments on social media when they're acting in their supervisory capacity versus maybe when they're acting as a candidate or frankly just as a resident commenting, which they certainly can still do. But I think everybody would agree where those lines are among those three categories, it gets really complicated.
Yeah, and that I think of, when we're talking about First Amendment issues, this topic in particular, I think of it as it's kind of a lawyer's dream. Because, you'll hear comments or terms like, there's no bright line. factors and considerations. There's no absolute rules. So there's so much detail when it comes to a First Amendment analysis that we're going to try to summarize as best as we can, but it's very difficult, to package a good First Amendment overview, but we'll do our best. So just to start off on our slides here, an overview of what we're going to discuss today. As Jake mentioned, we're going to talk about regulation of board member speech. And then regulation of public speech, to the extent a county can regulate the public speech from members of the public. And then board members, social media, the campaign accounts and public personal accounts versus that official accounts. And that, again, that's where we're going to talk a lot about the forum in which the speech is made on social media. And then we'll talk about the public records and the open meetings issues, which again, some of our audience may have familiarity with, but we want to talk about a few particular issues because frankly, when our open records and public meeting laws were written, social media didn't exist. And it's my understanding that, the courts haven't given us any definitive answers. So there's lots of what we could consider as guidance, but again, lawyers dream of those gray areas.
Yeah, and that's a really important point. Anytime we have entire presentations that we do on public records and open meetings, social media is, I think it's a good way to put it. The law is, I don't think it's an exaggeration to say it, like decades behind on where the technology actually is. I was just in a county last week, helping a corp counsel and their IT navigate, well, how do we actually retain these social media posts and comments? And unfortunately, there's not a great answer right now, right? Because the law says one thing, and the Attorney General, through its public records compliance guide, has been very clear, yes, we need to retain those pursuant to a normal retention schedule. Okay, that's great. The poor county IT folks are asking, well, how do we go about this? And it's not that they don't know how to do it, it's more practically, where are we getting all the storage? Who's paying for it? Is the IT department, and the IT department's looking at their budget saying, we don't have the capacity to store all this. And so, yeah, that's for a different presentation, but when you're talking social media, it almost always evolves into a conversation about public records and retention. And so again, we have presentations on that, and we'll touch on that at the end. But absolutely, this is an area where we're going to dissect kind of the First Amendment components here, but the law isn't even close to catching up to where the technology is.
Yeah, and I don't want to jump ahead too much, but you raised some really important points. And I think that, from a threshold standpoint, it's important for us to recognize that social media does play such an important role in not only county government for departments to, make public announcements, but also obviously for elected officials to be able to communicate with their constituents or non-constituents and so forth. And every individual is, when they're posting as a government actor, that's where we get into our First Amendment analysis. It becomes very difficult. Like there are not even no bright lines, but like big gray lines.
Right.
So complex, but super important topic today. So with that, we'll start with our attempt at a First Amendment overview. The fundamental to take away is that the statutory definition of record, which is in 19.32, includes electronic records, which includes social media posts. So right off the bat, we know that a public posting is a record and is a form of speech. That's kind of said that a little bit backwards. So with that, we know that when we are doing posts on social media platforms, we have to apply that First Amendment analysis.
Yeah, and I guess I would also highlight from a kind of a fundamental standpoint, you need to, when you're looking at a First Amendment analysis, whether it's, the federal First Amendment, or we have a free speech clause within the Wisconsin Constitution, that we're looking at government action, right? That's really important. I think sometimes individuals get this confused, right? If you have an individual that's preventing another individual from speaking, again, whether it's in person or social media, right? If that individual, and this is what we're gonna ultimately get to, if the individual is acting in an individual capacity, that's not implicating the First Amendment right. We're talking about government action here. So either the county itself is taking action to somehow prevent speech or not, right, depending on the analysis, or an individual county supervisor kind of acting under the color of the state is taking that action, right? And so that's like the most fundamental point as we start is, right, the First Amendment protects from government speech.
Right.
Or protects speech that's being prevented by a government entity. And so as we go through the slides here, that line, it should be obvious, but it gets blurred. When is somebody acting as a county supervisor versus an individual? Because if it's in an individual capacity, the First Amendment protections may not be implicated.
Right, right. Good point. And I think, when we're talking about the fundamentals of what the Wisconsin State Constitution and what the US Constitution tell us, I'm going to just summarize what you just said. A government actor, it has to be a government actor, cannot abridge the freedom of speech, So even just that short clause, when we break it down, again, as you mentioned, there's the government action. As a government officer, like you indicated, and we'll talk about more, are we acting as a government officer? Are we acting as a private citizen? Are we abridging the rights of another? So that, again, that very straightforward sentence in our Constitution has a lot of different implications and a lot of different factors. Do you want to go from?
Yeah, so I mean, the way we kind of have this broken down is this first category is to me, so the actual county regulation of board member speech, right? This can get hairy, as we all know, right? So you're gonna have individual board members that want to speak, right? You're gonna often hear the refrain, I have to have the ability to speak to my constituents, and that's absolutely correct. And so the question will often arise, what happens if you have a board member that's, let's just say, going off script, so to speak, where the county maybe has a set of priorities and you have a county board member, or maybe a subset, a minority of your board that's they're not supportive of kind of that majority direction. Where does that line lie as far as what the county can do to regulate that sort of speech? And so I think, right, we're going to jump into the details here, but it's fair to say proceed with caution, right? Because, an individual county board member, and we preach this often, right? They don't speak for the county, right? That's typically, right, the chairman working in coordination with the administration is going to kind of put out that vision, that direction, right? They can't necessarily commit to an action because that's going to require board action, but they're kind of like the spokesperson for the county. But we often will emphasize when we're doing these presentations that your individual county board members can still speak, right? I think sometimes people misinterpret that as, well, okay, so you're telling me the chairman is the only person that can speak for the county? Well, yes, from a formal standpoint, but certainly your individual county board member, right? They're elected, they have a constituency, and they have the ability to speak to policy questions. They're not speaking for the county, but they can certainly express their opinion with respect to county policy, and you can see the friction there, right? And so this first category, I think, is probably the most important that we're going to talk about today, because in my experience, I'm assuming you would agree, this is where the questions often arise.
Right.
Administration, county chair, maybe rightfully so, have a county board member that they're just not on the same page. And what can they do to address that? Sometimes you may even hear control, and we just have to be really careful. Right.
And some of you may have attended some of the other in the boardrooms or other presentations that Andy and Attolles has done regarding unruly board members. So this this element of freedom of speech and controlling speech oftentimes arises within the context of, the chairman controlling an unruly board member. So there's a lot of crossover there. All right.
So this is from just to, if everybody can allow us to nerd out for a second here, right? So the First Amendment is obviously multifaceted, right? You have freedom of speech, religion, press, assembly. And within kind of that freedom of speech, there's also layers. If you look at kind of the decades, centuries of case law relating to freedom of speech, there's kind of subsets of speech. And I think it's fair to say political speech, as we kind of note here in the first bullet, is the second bullet, is really the most protected form of speech if you look at kind of the case law, which obviously leads to a lot of contentious debate within the country. Campaign finance, right? Campaign finance is a very hotly debated topic. Well, really, that's because it's ultimately based on a First Amendment protection. And then the courts have looked at that and really given a heightened protection because that's considered political speech. And again, I know there's kind of both sides to that topic, but the point is political speech is definitely going to get heightened protection within kind of that First Amendment application. And so we just wanted to emphasize, we're talking not only First Amendment, but kind of embedded within the First Amendment is the political speech. And again, so when we say proceed with caution, it's because if you look, and there's certainly always exceptions, you can find case law that maybe goes, and we'll get into some of the case law that goes the other direction. But for the most part, case law is going to suggest that courts are going to look very warily on any kind of government action that's going to impact political speech.
I heard once that and for me, the best way to remember, that political speech, that public forum speech is speaking from the courthouse steps or speaking in, the town square, those situations where you traditionally think of people, making speeches or advocating or, having those very public, robust discussions. So that's a good rule of thumb, at least for me, to hone in on what that political speech, and as you indicated, a key point, that it is the most protected. And so we'll get to what the courts apply, but again, the most protected, and the courts are going to apply a strict scrutiny standard.
Well, and to your point, when we note here the application in this slide, your I guess kind of example is a good one. Speaking on the steps of the county courthouse, right? Clearly maybe delivering a county message or a county policy position. It's clearly going to be kind of that you have your county board hat on. It's very obvious what you're doing. The problem with social media is those lines get blurred, right? It's very easy kind of in a traditional sense. Yes, I am in the county courthouse. I am conducting county business. I am at home, in my living room, in my personal capacity. The problem with social media is, right, it's not just your physical location. You can be sitting in your living room and maybe putting out a message via social media that to the public is going to be viewed as a very formal communication sent on behalf of the county.
Right.
And you can be doing it from, your pajamas in your living room. And so that's where I think social media, to your point about the law, really, or the technology far outpacing the law, the lines just get so blurred and messy by social media.
Yeah, that is a key point. And I think that, again, we're talking about the no bright line rules and these blurred lines and parameters that social media creates. And again, the law has not caught up to the technology.
Right.
And, technology that particularly after the pandemic, we are all very familiar with, and county governments have really incorporated, that kind of remote speaking from the courthouse steps. And what does that do? All right.
So we've been talking a lot theoretical, but we just wanted to make sure that there was kind of a fundamental understanding of government action, the First Amendment, and then political speech. And those are kind of the three building blocks. This is where we get into hopefully what you all consider to be the practical. And so we put this together, and I think this is a really helpful chart And we're gonna be going into all these 5 categories in detail. So, we kind of view it as 5 touch points when you're looking at this First Amendment protection of elected officials. So the first one we're gonna talk about is county board members' expression of their political views on social media. They are protected, right? But then we're gonna kind of go through this progression and hopefully, I think in particular, Rebecca and I were talking about this beforehand, we think those last 2, D and E, are really important because these are the issues we hear often. Okay, we have a disruptive member. And again, disruptive being right, that there's a clear consensus on the county board, or at least a majority, to take some sort of action. And you have somebody who's just completely opposed, which they have a right to do. But it's not infrequent that we get questions relating to, look, this one board member or this one block, they won't stop debating and opposing what we're doing. And that's hard. We understand that because we often encourage, consensus and moving forward on a policy proposal. But at the end of the day, right, these are still dynamic boards, and you're going to have members that disagree. And so where is the line between healthy debate in opposition and too much? And that's to use the lawyerly phrase, like that's always going to be case specific.
Very much.
And it's not going to be clean. So, I think we can just jump into this first category.
Right. We've got a lot of case law and a lot of analysis in these slides, so we're going to kind of go through those fairly quickly so we can continue on with the meat. But as we mentioned, it's hard to compress all of the First Amendment details into a shorter presentation. So should we skip this one then?
I mean, yeah, this is really just case law. But we want to make the point. I mean, this is US Supreme Court case law, basically kind of outlining that these, and I would say the third bullet's the most important point. Legislators have an obligation to take positions on controversial political questions so that their constituents can be fully informed by them and be better able to assess their qualifications for office. Also, so they may be represented in governmental debates by the person they have elected to represent them. So, good. We've kind of bungled along here. I mean, this is the Supreme Court with, I think, a perfect summary of what we've been saying. These legislators individually, right? Not as a group. That's kind of a different analysis. Individual legislators have this obligation to take. I mean, it's an obligation, right? It's not, the ability, right? It's an obligation. Right, they're elected to take action. I mean, another way to look at this is, well, legislators could just simply be in their position and abstain from every vote.
Right.
I think it's fair to say constituents wouldn't support that legislator going forward, right? They elect them to take positions, and if ultimately they get to a point where they're taking enough votes, the majority of their constituents disagree, well, that's why we have elections.
Right.
Right. And so I think, the takeaway here is that the Supreme Court has made clear that they have a right to express their personal views, opinions, and positions, even if unpopular, during an election process, during board action.
Right.
And then again, if it becomes a point where it's so unpopular, well, there's an electoral mechanism to do that.
Good, great summary.
So I think this is, and I like, Rebecca, how you put like on the courthouse steps, right? The use of trappings of office. I think, we could spend a lot of time on this topic, but if you look at kind of this third bullet, a county may restrict the use by a board member of county-specific resources to tout any number of personal undertakings. And, when we were putting this together, I think it's important to highlight, obviously, the potential for personal conflicts with business exploits, financial causes, fundraisers, things like that. What we should probably do for the future here is also note, I think the most important one is campaign activity. Right. And so this is where you're going to have county boards, administration have, I think, a very distinct role in ensuring that the trappings of the office, i.e. county resources, are not being used by individual county supervisors to advance personal interests. And again, I think while it's important to outline, the potential financial implications and things like that, I think where this often comes up is campaign activity, right? So you have a county supervisor that wants to, maybe use some county resource to advance their own, political agenda, so to speak, which, and I don't mean that in a negative way, right? They run for office, they need to outline what their vision for the county is. That's all part of the electoral process. But can they use county resource to do that? Obviously not. But I think there's a lot of gray there, in the sense, think of newsletters, things like that, right? There's gonna be, I think, some gray between, is this a formal communication from the county supervisor or the county board, just simply communicating to constituents what the county has done or where it wants to go, versus county supervisor Joe communicating to his constituents about how great a job he's done and why, hint, hint, in April, it really would be helpful to get another term. Obviously, that's almost a childish example, but I mean, I think the point would be, right, we have to avoid that use of county resources. So this is an example where the county, I think, has the ability to step in, right? Because we're talking here within the First Amendment context. It's not difficult to foresee a situation where the individual supervisor says, whoa, hey, you're infringing on my First Amendment rights. I think if the county can look at that situation and say, look, you're trying to use county resources to advance your own personal, political, or certainly financial position, that's where I think a county is going to have the ability to maybe more vigorously regulate that activity. Right. I don't know if you would agree with that.
No, I would agree with that. And I think that, one approach that I've seen some counties take to address that issue is within the context of their ethics policy or the, an ordinance relating and addressing the ethical obligations of supervisors. One of which is not to use county resources for those own personal exploits or where there is a benefit that meets the statutory definition of inappropriate. So it's so fascinating that, we talk about all of these different issues and obviously they have this First Amendment component. So the next, this point, again, a lot of detail here, but the issue is when county board members are actually voting and they're engaged in the actual voting process. And for me, this is always a challenging issue because, voting is such a fundamental part of doing one's public duty as an elected official. You're voting. And so the courts have looked at this and said that in that process, a county can impose restrictions on the ability to vote of certain board members without running afoul of the First Amendment. So, and again, those restrictions being for the public good and being neutral.
Yeah, so I think that's a good summary, and I guess I would point out here where if you initially look at this issue, it does seem counterintuitive in that voting in your official capacity is, I think, considered in this very fundamental right. In other words, that the government entity, in this case the county, really can't ever restrict that. I think initially where people would go with this sort of analysis. But if you think about it, there's all sorts of ways in which that ability or right can be restricted. And I think you actually on the previous slide hit on the most important one. Here in my notes I have underlined ethics. Or if you think about an ethics code, that's an entire framework that essentially controls someone's ability to maybe take a vote or even serve in a position, right? We've had different presentations on when individual supervisors, for example, get elected to a different county position or get hired into a county position, right? And we don't need to get into the details on kind of the inconsistency within those positions, ultimately in some situations leading to an individual having to resign, right? And so if you think about that, that's in the most fundamental of ways preventing that person from voting. But when you think of it in terms of ethics and ensuring that you're avoiding personal conflicts of interest and financial gain, then I think it makes sense that, yeah, I mean, voting in your capacity as a county board member is fundamental and it's important, but the county as an entity can certainly control it. Again, not necessarily directing you how to vote, but allowing a framework to be put in place by an ethics code that kind of puts up guardrails on when somebody may not be in a position where they can cast that vote, right? And maybe an individual vote where they have an individual conflict, right? You know, some vote on a budgetary item where a person's gonna have a personal conflict. Well, you have a conflict there, you need to have to abstain. But then all the way to the point of you cannot hold this office any longer. So I think you're right that I think most people start from the standpoint of it's fundamental, but that doesn't mean that the government entity, i.e. the county, cannot regulate it. It can.
Right, right, and that balancing. So much of what we do is that balancing test.
Right.
All right, next item, a county may not retaliate against board members for negative but protected speech. So again, this is where it digs deep into having to determine what is protected speech. This goes back to ethics codes or county board policies or county board rules that are intended to secure a nice clean order of process and one that is respectful of all members. And so what do we do if those policies maybe go too far and there is some sort of retaliation? And the courts have told us that you can have those rules, but they cannot chill a board member's speech. Now, what the heck does that mean? Again, lawyer's dream. So a county could not prohibit a board member from speaking about the public or with the public or on social media outside of the political arena. It does violate their freedom of speech. But prohibiting them from speaking on behalf of the board likely does not. So again, that's where we get into the analysis of in what context is the elected official speaking? Are they speaking on their own behalf as an elected official? Or are they speaking on behalf of the board? I'm Rebecca, I'm a county board member, and I speak for the county board. That's where we get into the problem.
Yeah, so in my opinion, this is our most important slide. And it's also, I think, the most difficult one from a practical standpoint. Because as you said, the language is relatively ambiguous when you look at the cases here, because they're going to focus on kind of this chilling effect. And I think one of the reasons we highlighted this case, again, this is a US Supreme Court case from 2006. But when you consider the facts, this is probably one of the cases where I think it makes sense to actually get into the facts. So in Hartman, the vice president of a school board was demoted from his position as an officer after he made a denigrating comment about the district superintendent of the local newspaper. I think there's a lot there, right? So you have somebody in leadership who, and I don't recall what the denigrating comment was. I mean, let's just assume it was just something negative, right? I think the superintendent was a horrible choice, right? And obviously, put it in the county context, I think our decision to hire this administrator was a wrong decision. This has been a disaster. And let's say that person is the vice chair. So the Ninth Circuit, when they looked at this, they said, although the demotion stemmed from his contrarian advocacy against the superintendent, the board's actions did not amount to retaliation in violation of the First Amendment. So, because in this case, the individual is demoted from their leadership position. I think some people would be surprised by that outcome, right? So again, in this case, a board member, the vice president, makes a comment against the superintendent, right? And just insert vice president or the vice chair of a board against the administrator, wherever the context would be in county government, and the person's then demoted based on the speech. And so I think this is a tough decision. And I think again, when you're looking at this, it's got to be fact specific, because I think you could see scenarios, and you said it well, where it just goes too far. Where that is, I think this is where you gotta work with corp counsel
Mhm.
and again, proceed with caution. Because if you're gonna actually prevent it, that chilling effect, what does that mean? I think it's gonna depend on every single situation individually. But if you cross that line, and the court maybe could have helped you, and gave a little more definition as to where that line is, but if you cross that line to actually chill that individual's ability to speak,
Mhm.
then you have the problem. And I think that gets into kind of the second key point here. Like you said, you can take action procedurally, according to the 2006 case here, so long as it doesn't chill their speech to communicate in their individual capacity as a board member.
Mhm.
Now, so we have almost a second analysis there. Where's the line between speaking for the board and speaking as individual? That at least I think is a little more clear. Right, again, individual supervisor, so let's just use my hypothetical, right? They disagree with the hiring of the administrator. Okay, they can say, I disagree with the hiring administrator, for reasons X, Y, and Z.
Mhm.
Okay, I think that's speech they can engage in. I think maybe crossing the line is, the board, I've talked to my fellow county supervisors, we're all in agreement that this administrator needs to go, and it's gonna happen next month.
Mhm.
Okay, I think you've crossed that line. You're not speaking for the board. You can't make that statement. The vote hasn't even taken place, and you don't know that unless you've been having consistent walking quorums, which we'll get to in a second, you're not gonna know that.
Right.
So no, you can speak on your own personal behalf, but you can't speak for the board, you can't speak for the county.
Mhm.
But again, I think this is a really loaded slide, and this gets really complicated.
Mhm. And taking that too within the social media context, I'm sure we can all imagine how, someone posts a comment disagreeing, as a county board supervisor disagrees with, a county administrator action. And then as those comments build up and build up and build up, then that enters into the analysis. Like, I spoke with a whole bunch of my, fellow county board supervisors. Well, if you've got a whole slew of county officials then commenting on that first comment, how is that translated? So
Right.
just a practical point. Okay, so we have 20 minutes left. Us lawyers, we could talk about this stuff all day, so we'll try to keep it moving here. And of course, we're always available for questions after. All right, managing disruptive or unruly board member behavior. As Jake indicated before, this is a very, probably one of the most important slides. And again, we're looking at this through the filter of social media and First Amendment. So why don't you give us your summary on that?
Yeah, I mean, I think this is a question we get a lot, right? And it was kind of how we started the presentation, where the member or group of members that's not on the same page with maybe board leadership, administration. What can you do? Right, you have to allow them to take positions that they want, but they can't speak for the county. So now we're kind of getting into truly, I think maybe a different category, and that is not to say it always has to be an individual member, but I think in our experience, when you're getting into this category, you are getting into the category of somebody who, right, they're not even necessarily part of one faction or another.
Mhm.
They're just kind of opposed to maybe everything the county is doing,
Mhm.
right? And they're just not a productive member. And almost, unfortunately, sometimes we see even harassing type of behavior. Or in this example that we have, just something that's completely inappropriate and really does not put the county in a good position,
Mhm.
results in public outcry. What do we do with a member like that? Because again, if they're rightfully elected, they have the right to be in that seat.
Mhm.
And so, short of some recall attempt, which occasionally we see happen, the board leadership is left to kind of manage the situation. So again, using this example, somebody makes an inappropriate comment. What do you do? Well, I mean, I think we have some practical, this is maybe one of the first slides here, which is very straight, practical advice. And that is, how should a county board react? Again, within the First Amendment bounds, short of a recall, request that they resign.
Mhm.
Say, look, this is just not working. You can't make comments like that. You represent the county in your role as an individual county supervisor, not the county. But this is the problem. When you're making comments like that, you know, people aren't going to just kind of cabin them as well. It was just your individual opinion. They're gonna say, look, this must be the perspective of the board.
Mhm.
And it just puts the entire county in a bad position. And so you can have that conversation to resign. And then if not accepted, and typically when we've helped counties manage this, they're not going to individually resign or voluntarily resign. And so you can look at a public censure, which I think oftentimes people react, well, that's just a slap on the wrist. And yeah, that's really what it is, right? It's a public statement and vote, basically outlining that the majority or maybe even every other member of this county board does not agree with this individual county supervisor's statement or position. And so on the one hand, yes, it's really a slap on the wrist and nothing more. But on the other hand, I think there is benefit. And again, particularly, and again, we're in social media, the context of social media, I think sadly, you see a lot of this within social media, right? What's the term, keyboard warrior?
Yes.
Right, so people are far more willing to say really nasty things via social media as opposed to when they're on the board floor or even just in a different public setting face to face. And we can get into all the human nature aspects of that, but that's just the reality. And so when you're dealing with social media, in fact, if we probably sat down and put together the most recent examples that we've dealt with, I think most of them have been social media, right? Somebody says something just absolutely unprofessional on social media, really putting the county in a bad position. And then the county board chair or administration is notified of this, and then ask, well, what are we gonna do about this? Those are really difficult situations to be in.
Very difficult. And I completely agree that when I've seen the questions of censure come forward from counties, they have been within the context of a social media statement. And I don't know about you, but I'm seeing public censure as an option used or discussed more frequently than in the past. And I think it's directly related to, that the increased use of social media and the ability to say things when you're at home behind the screen in your pajamas that you may not say on the public floor. But again, it's the same thing. One point that's key throughout all of these slides is that as a public official, your intent doesn't matter. If you say one thing is one thing, or if you call your private Facebook page private, if you're talking about government business, it doesn't matter. You may still have an issue. So again, intent, courts aren't going to look at what the intent is.
Right now, and I think we have I'm not sure we're gonna have time to get to it, but that's a really important point. I wish we had time to get to it, but yeah, so what you kind of touched upon, I think is critical in that when you're looking at social media, I always encourage supervisors to make clear when they're on social media, what account are they using? If it's your personal Facebook account, fine, it's your personal Facebook account. If it's a campaign account, that's still going to be kind of considered, personal within this First Amendment kind of context. But then if you're using a, County Supervisor Joe, his official Facebook account, that is different. And so, yeah, we can just kind of jump ahead because I think that last slide was just, relating again to that disruptive board member. But so this is what you're talking about, kind of the different platforms. I think what you were touching upon from a First Amendment standpoint is really important. That is the public forum analysis, right? So you're gonna have a traditional public forum, sidewalk, very limited role for the government to ever regulate that speech, right? If you want to go on a sidewalk, and in the social media sense, if you just want to go on social media and scream into the wind, you can do that, right? We're really being focused on the kind of this limited designated public forum, because in the third category is the non-public forum, essentially the office space. Courts have recognized, and I know Andy has done a different presentation on this, that look, there's going, the public doesn't have access to every square inch of a public facility. There's going to be non-public areas where the individual staff and department heads can go about and do the business of county government. And so I think it's really this second category that's where we see the most debate and the most issues, and that's going to be the limited designated public forum. Think the county boardroom, right? It's not it's not the sidewalk, it's not outside, but it's also it's not you know a department head's office.
Right.
This is a relatively public space.
And on that point, another good common example that we see is public comments. So if a county board or a committee of the board opens the forum up for public comments, and again, I'm not talking about like within, you know, a legally required public hearing, but just public comments, whether it be public comments on agenda items or any other items. First off, people don't have a constitutional right to make public comments. That's, you know, again, within that typical setting of a board meeting. You know, if the board decides to open it up to public comments and it's not legally required, that's that's something the board can choose to do, but it doesn't have to. I think that's something that I frequently see as kind of a misnomer. But once the board opens it up to public comments, that's when we have to be very careful in terms of who we're chilling or stifling. And I think a good rule of thumb is can't be selective. Can't say that, you know, obviously only if you are going to support the county budget may you speak. But even things like whether someone is a resident of a particular county, can a non-resident speak? Anytime we get to being selective, that's when we get into some dangerous waters. And then how that translates again to the social media, you know, can we control those, you know, public comments on a particular page? And once we open up comments, how do we then draw that back in? And I think so why don't we just touch on that quickly?
Sure, and let's go to, I think this, the designated public forum slide, I think that's helpful.
Whoops,
Up there. So I think,
Wait.
Yep, that one right there.
This one?
Yep, so I think this touches on kind of what you're getting at, particularly within the social media context. So when you have this social media platform, right, and you're using that to communicate decisions made at the county board level or administrative level to the public, most platforms are going to allow for comment. And again, major kind of caution, if you are going to start to regulate any sort of speech, and I like how, you know, I think it's a good way how you framed it, like whether it's a social media platform or the county boardroom, do you have to allow for comment? No. So I would argue on a social media platform, you don't need to allow for comment. And I'm not a social media guru, but I mean, I think you can do that, right? You can just, we're gonna post, nobody can comment on it. We're just putting the information out there. It would be no different than as county board saying, look, we're gonna have our meetings, you can certainly attend, observe, you know, for this meeting, or maybe, you know, in the future, we're just not having public comment. It's not a right to have a public comment. But like you said, the second you open that, and you know, to kind of use the legal phrase, any analysis you apply has to be content neutral. In other words, if you're only allowing public commenters at your board meeting that are supportive of the budget, and you refuse to allow those who are opposed to speak, I think everybody would say, well, obviously we have a First Amendment problem. It's no different on social media, right? And so if you're gonna, you know, in the summer, put out the proposed budget that's gonna be debated in November, and you're going through and selectively deleting comments that are negative, you have a major problem, right? Now, where's the line between, you know, healthy debate, maybe, you know, certainly even negative versus hostile or threatening? I mean, that's where I think you can kind of get into the situation where maybe there's going to be a compelling interest on the part of the government entity to regulate that. But again, proceed with caution, because you're in that kind of middle public forum where, yeah, there's some ability to control, but it still is not robust, right? This is a public forum for the public to be able to utilize and express their opinions.
Right. So in many situations, a public official will have their official page, you know, Rebecca County Board Supervisor page. And these are in the slides later. So I'll just try to summarize. But so we've got the, you know, the official page, then we've got, you know, the campaign page, and then we've got the personal page. And it's always important to remember, even if my intent on my personal page is to not be talking county business, if after the budget board meeting, I go home and say, I cannot believe that we voted to fund this entity. That is my personal opinion, but it's also relates to public business. So at that point in time, my personal account has crossed that threshold into the, you know, a public forum. And so if I then had my comments open to the public, even on my personal page, and I shut it down, that could be a problem. So again, it's unfortunate that we don't have a brighter line to give public officials on what is private and what is personal. But it's just the reality of the rules and of what social media does.
I think it's the reality. I think that's right. But I guess maybe I would say this is one of those situations where because it's so muddy, I think the practical advice can be to try to keep it simple. So I would argue, and again, I understand that sometimes the lines can get blurred, but I also don't like the approach when you hear county supervisors say, well, it's too hard to do that. So, you know, I'm just gonna have one page and put it all on there, and it's still my page. So I'm gonna block people that I don't like. I'm gonna delete comments. I think that's problematic. My advice to those sorts of supervisors would be have 2 pages and keep it simple. If you can't kind of control yourself, then keep it simple. Have your public page where you're putting out, you know, the committee actions, the board actions. And my advice is, I mean, short of something unbelievably threatening, don't delete comments. You view it as again, to use the legal word, right? It's a public forum. And then on Facebook, you know, put your pictures of your kids and grandkids and you know, if you love something that Biden did, hated something that the Biden administration did, fine. If you want to talk politics, that's fine on your personal page. But when you're talking about county business,
Right.
keep it on that official page. And again, we have the cases, and we've just highlighted 2 of them. There's significant case law out there relating to, in fact, there's actually a few cases out of Wisconsin relating to when public officials can block. And typically it's Twitter, right? Because of the way that platform's set up, it's very easy to block somebody that you don't like from commenting. And then once they're blocked, they can never comment. So that's why actually a lot of the case law has involved Twitter. And the courts have been pretty clear. If this is your formal Twitter page and you're using it to disseminate public government information, it is a public forum.
Right.
And so you can't be blocking people.
Right.
Again, it would be no different than you're preventing the person from making a comment when you're allowing others to make the comment. Because again, then you're not being content neutral.
Yeah, and
Can I jump in here? Because this discussion that you're having, there's a few questions related to that. So
Sure.
building off on the questions to this discussion, there's one question talking about the option to shut off comments in total from Facebook, for example. So is that going to be an issue? And again, a second question related to that as well about just allowing comments, again, not being selective on certain people, but turning off comments for everyone completely. Your take on that?
Yeah, I think the trend, and I think this would be consistent with what our advice has been to counties, is to just turn off the comments. Because it's that selective nature of you delete some, but not others. That's the problem. Because if it is a public forum page, then it has that the greatest extent of freedom of speech protection. And again, we apply the strict scrutiny test. If we eliminate all comments, then we are not making content. We are making content neutral decisions by turning off all comments.
Yeah, so I mean, I think we're attempting to answer Cameron's question. Cameron, it's a really good question. You just say you're curious as to kind of how these platforms can be, because they are private platforms, how they can be considered public forums. And I think the way the courts have, and I'm obviously summarizing here, but if you read any of these cases, the way they look at that is the reality is most individuals get their information now from some social media platform.
Mhm.
And so the courts have looked at that and says, this is the public billboard from 1950, right?
Mhm.
This is the newspaper notice from 1950. And so this is an example of where, the law and technology are not in sync. But the way the courts are looking at this, it's if we're going to protect and require notice on the billboard in the newspaper and then allow people to comment or to kind of absorb that information, how is it any different if they're getting the public notice, reviewing meeting minutes and agendas on Twitter or
Mhm.
Facebook or LinkedIn? It's no different. That's the way the courts have looked at this.
Mhm.
So good question. But that's the way the courts have looked at that. And we'll just try to rip through these remaining questions. So James is asking regarding speech and postings, is liking another post or reposting another posting, is that considered speech to be kind of avoided? Great question.
Great
I
question.
mean, I've actually had several, investigations and reviews relating to who liked whose Facebook post. I mean,
Mhm.
I think it's fair to answer that question. Really, any activity is going to be on a social media platform like that is going to be considered speech. Because so, for example, the reposting, I mean, it's certainly, you can take an article and you can repost it. Maybe you just repost it, or maybe you repost it with comments. But either way, you're communicating a message, even a reposting,
Mhm.
right? I mean, you're advancing, maybe in that case, somebody else's communication or message. But I still think that's going to fit within that category of protected speech.
And the same with a like. I mean, I think that, yes, you're just checking a box for a thumbs up, but as you noted, you're still advancing a position. You're still communicating a type of agreement.
Correct.
That's,
Yeah, correct. Robin asked a good question. During a debate in a meeting, a member talks about other issues not germane to the question at hand and refuses to stop talking. How should a chair handle this? Great question. I would argue, I mean, yes, that board member has the right to speak, but you're getting into Robert's rules. You're
Mhm.
getting into frankly open meetings, right? I mean, Robin framed it well. I mean, if they're talking about something that's not germane, right? What's always the risk with that? The risk is you're going to start talking about something that's going to spur other discussion,
Right.
other debate, and all of a sudden now you have a debate about something that hasn't been noticed.
right.
So I think in that situation, I mean, yes, you may have some First Amendment implications, but actually, I think you're limited by the fact that the board has the ability to run its meetings,
Mhm.
and you have the open meetings law requiring proper notice. And so I think in that situation, where exactly that line is, I mean, that's ultimately for the chair to determine. But I mean, I don't think in that situation a board member can simply just shout First Amendment and
Right.
succeed. I
Right.
think it's a different analysis.
Different analysis, absolutely. And I would say the easy answer is shut it down. I mean, and this is an example of where a board chair's position is really difficult, because when a member or a board member becomes unruly or is going off topic or, deviating from, the issue at hand, it's up to the board chair to get that person back in line.
Right.
And how do you do that? And that's where, the board chair can look to board rules or Robert's rules or things of that nature. But it creates a difficult position for the board chair to have to control those types of individuals.
Yeah, and I know Sarah's gonna probably cut us off here with two more, and I'll try to just quickly answer them. So we have a question from Sheriff. It's a very good question regarding the retention of and the preservation of comments. I literally had a 2-hour-long meeting last week relating to this issue. Sheriff, I would actually encourage you to reach to us offline, because that is another example of where really difficult situation. I would argue the retention schedules are just simply not in line with the technology and who controls those comments. Right, you're talking about essentially third-party vendors that are not on a county server. It gets really complicated. I will just say, again, the retention schedules, how long you need to preserve these communications and these records, create all sorts of IT headaches. And there's just not a good answer right now. I mean, we can try to help, but the reality is it's kind of an IT nightmare. And frankly, DOA, the Department of Administration that maintains the retention schedules, has said they're going to address this, and to my knowledge, have not, but they need to. And I think the last one here, if you turn off all comments for a post, should you do that for all posts on that page, or is it okay to pick and choose the posts for which you turn off comments within a channel? Great question. I would argue, I think this is now probably the 10th time I've said this, proceed with caution. The way you frame it may sound okay. I don't think it's difficult to foresee a situation where you're picking and choosing maybe issues where there's support for where the board is at or the administration's at, and then maybe shutting off comments for those that aren't. I think, I don't want to say for certain that you could never do that, but if, for example, you're shutting off the ability to comment on individual posts where there's a lot of public pushback, I think you're getting into a difficult territory. I don't know if you agree with that.
Yeah, I agree with that. And I saw this with counties during COVID, you know, where counties would post information via their public health department, and there would be a lot of feedback, and then the comments would be turned off. And so, you know, applying that analysis of, you know, is it important enough to turn them off in order to share that public message, and weighing all of those factors becomes very difficult.
Well, and I guess my final point would be, if you look at the case law on these sorts of issues, whether it be public records, open meetings, courts are going to come down pretty hard, knowing, so for example, in an open meeting context, if you're putting out notice and not putting out proper notice for something where maybe the public entity knows there's a lot of public interest, courts have not looked favorably on a government entity in those situations. In other words, if you know the public is really interested in this, and you know you're trying to get cute with an agenda notice, you're gonna walk yourself into a big problem. And so I would say same thing here. If you know there's a lot of public interest in a topic, and information is being posted, and for just that post you're shutting off comments, I don't know how that's any different than if you're trying to get cute with the public notice, knowing that the public may be really interested and maybe opposed, right? I think that's a problem. Last one here from the sheriff again. I would say that's a really good question. He's asking about Facebook and kind of individuals and how they identify themselves. Again, proceed with caution. If you start to single somebody out, I think that could be problematic, particularly if it's somebody that's very vocal. But at the end of the day, you know, that's going to be case by case.
Yeah, let's use just kind of circling back to the beginning when, you know, Sarah referenced, you know, my performance as that obnoxious member of the public. You know, that reason that resonates is because I know many counties have those. So that person, we could just say that person, can you block that person or block one person? And the answer is no. Again, it becomes that selective picking and choosing. And that's where the courts say, no, you cannot be selective in who you allow or who you do not allow to speak within that public forum. And again, the Twitter and Facebook is the public forum when you're talking about government business.
Right.
I think we should do a whole other in the boardroom on public records and open meetings on social media, because we did not even touch on those slides yet.
Yeah, I mean, that's naturally where this stuff leads is because again, the standing in the boardroom physically, I mean, those are, I think, easier to deal with. But the reality is a lot of these issues take place over email, text, social media, and all along, everything I just mentioned, right? It's all about the content. Doesn't matter what platform you're using, the release of government business, you're creating a record. And so, and then, like I said, notices, things like that, those are all open meetings implications. So yeah, we could have numerous presentations on all these subjects because, again, and I guess this will be my final point, that the law is decades behind where the technology is when it comes to public records, open meetings, and social media.
Great point to close on.
All right, thank you so much, Rebecca and Jake. Great job today. I did make a note to add as a future topic, public records and open meetings as it applies to social media. But we do have other in the boardroom topics already chosen and scheduled for the future. So I want to thank everyone for joining us today. And I want to invite everybody to join us again on February 28th for our next in the boardroom, where we will be discussing the April county organizational meetings. So again, Rebecca, Jake, thank you so much. Thank you, county officials, for joining us today. And I hope everybody has a great rest of their week, and we will see you again in February.
Thanks, Sarah.
Thank you.
Bye, everyone. Oh.